Hi there. Welcome, everyone, and thank you for joining. We are so excited to have you here with us for today's webinar Strategies for Entrepreneur Green Cards. My name is Vishal Rai, and I'm the CEO of VisaNation Inc. Before I introduce our speakers, there are a couple of housekeeping items I'd like to go over first. First of all, this webinar is being recorded and it'll be available on VisaNation's website and also on our social media pages for you to watch it again. And for those who signed up but could not join today. Second, while we have a slide deck for this webinar, our focus today is on having an open discussion as we go over the best strategies and different real world scenarios for startup founders, entrepreneurs, business people to get a US green card. We'd like to make it an interactive experience for all of you. So we highly encourage your active participation in today's webinar. So please make sure you post your questions for us right below using comments. And remember to mention your nationality and the industry you're in, or the industry your company is in, and also the green card category that you are interested in. Please keep your questions general in nature, as our speakers can answer any case-specific inquiries or questions. So yeah, be sure to keep your questions ready for our two speakers throughout the webinar, and we'll do our best to get through all of them in the Q&A session after the presentation. And finally, all of you in attendance today will also receive the slide deck by email later this week. So please keep an eye out for that. So with the housekeeping items out of the way, let's get started. So our first speaker today is Sang Kim. He's a senior counsel with VisaNation Law Group. Sang has almost 2 decades of experience in business immigration and global mobility. He's worked for large law firms and also as in-house counsel for multinational corporations. Our second speaker is Shilpa Malik. She's the managing attorney of VisaNation Law Group. Shilpa has over 15 years of experience in US immigration. She's assisted hundreds of companies with business immigration, strategy, compliance over the course of her career. With that, now I'll hand over to Sang. Sang, we are glad to have you here with us.
Excellent. Can you hear me, Vishal?
Yes.
Fantastic. Thank you so much for the intro. Good morning, good afternoon, everyone, depending on where you are. I'm going to, my name again is Sang Kim, Senior Counsel here. I'm going to begin our presentation by talking about the agenda for today. So, with that, essentially we're going to assume that like most of our clients, that you will be looking to obtain some sort of initial status here in the US to live, work, and travel as you pursue your green card, since a green card effort in almost all cases is a multi-year event. Then we'll move into the actual substantive green card strategies outlined for today towards individuals who are self-petitioning or self-petitioning through an entity that they control. And then we will then close with some timing and plan considerations. As I said, it's quite a long timeline of efforts, and there are things we would wish you to be mindful of. And then we'll conclude with hopefully plenty of time for your questions and answers to the end of our presentation. So with that, let me begin by talking about the various bridge and visa strategies, and initially starting off with the E1 and E2 treaty visas. I won't go too much into detail of all these visa requirements. Much of it's already covered online, especially on our website. But I will kind of outline a couple of key issues or features we've encountered with our clients regarding these various case types. So with the E1, E2, these are visas benefiting the nationals of countries that have an existing treaty trade with the United States. If one is a national of that, and looking at the questions, I was just kind of glance at Canada is a qualified treaty country. If you're a national of that country, then you may be able to apply based on your entity trading goods or having substantial investment. the common question comes up is about what is substantial investment, since this is not covered explicitly in the regulations. And I would direct that to be essentially, it's a reasonable person's point of view of what is enough money to begin your US enterprise, depending on what the enterprise is. So it is basically your burden, but also your opportunity to outline to the various government officer or service center what you will be doing and why the money you have accrued, whether it's a pop-up restaurant or a multinational corporation or consulting business, is sufficient to begin that enterprise. Then we move on to the H-1B case type, which is by far probably the most popular or well-known volume work visa. But there's a particular interesting caveat with that when it comes to entrepreneurs and individuals. There needs to be an existing employer-employee relationship. And the way USCIS and the various agencies define that is that it is a entity that employs the employee and has hire and fire authority. This becomes problematic when one person is the only owner of the company or the majority owner, since that would make it problematic to define that person as someone who is a genuine employee as opposed to the owner of the company. So oftentimes when we have our clients founding a company, we need to direct them or advise them that they need to become either a minority shareholder or implement some sort of corporate structure that that will be acceptable to demonstrate that they could hypothetically be fired for that entity. Now, this is a bit of a risk assumption, so I understand that this will be a bit of a trade-off for some. So we move on to another visa, which is more suitable for a majority shareholder, which is the L1A. This multinational visa is available if you have an existing entity both abroad outside the U.S. and are entering the U.S. to begin a affiliate or wholly owned subsidiary within the U.S. One of the issues that comes across with this is the intent is to use this as kind of a bridge towards a green card strategy, and there are funding or operational costs. So many of our clients kind of wish to phase down or make it as minimal as possible. But unfortunately, that is a bit contrary to the multinational structure that USCIS is looking for. So for instance, we've had clients who started their small business outside the US. They've come into the US to start their business again, and then they've tried to transition to a green card immediately, even though there is either one or none employees anymore outside US, and there's only one or none direct reports in the US. So that minimal structure, it would not be conducive to an approvability. So a lot of what we're going to be discussing here is a sense of kind of like that this is not a one size fits all strategy. There are many avenues. They all have trade-offs, and it all depends on the type of business or type of pursuit you are pursuing here in the United States. We move into another visa that is often utilized by our individuals and entrepreneurs, which is the O1 extraordinary ability. Managing attorney Shilpa Malik will cover this in more detail in later on in the presentation for the parallel green card process. But to the O1 extraordinary ability summarized has quite a number of checklists for possible evidence. And the wording of the regulations make it seem like if you meet at least 3, then you're good to go. But it's a bit of a misunderstanding that this is the minimum to apply. It's not the minimum to be approved. And so there is a sense of that the extraordinary ability really needs to be manifested in the evidence you presented, as opposed to the bare minimum is suitable for an approval, which is, in our experience, is not. And it's, shorthand wise, what a USCIS officer is looking for. And this is a person who has no subject matter experience in science, arts, entertainment, engineering, mathematics. They are looking at the evidence based on a checklist or a protocol set for them by the department or service center above them. And they'll be very restrictive and narrow in how they look. And what they're essentially looking for is a demonstration that all the evidence together demonstrate that you are at the top of your field, and that this is substantiated by third-party objective evidence in media, in press, among the top of the peers. So something we'll cover a little bit more later with the green card connection to it. Finally, we'll conclude with one of the more recent bridge statuses called the entrepreneurial. This is not a visa status per se. This is a ability to obtain work and presence and travel authorization in the U.S. if your entity, your startup as it were, has sufficient capital investments from third parties. Unlike the E1, E2, which is more of an out-of-pocket effort, the entrepreneurial actually requires that this capital investment be from third party, usually VC funders or the government. And that capital requirement is $250,000 for private investors and $100,000 if they're federal or state related. So, the capital requirements becomes quite a bit of a very specific, narrow approach. And, it's something we absolutely recommend being looked at before you pursue your visa or green card strategy, as these documents are asked for in quite sufficient detail. Normally a tax return, an audited statement are what is required. Internal profit loss statements, PowerPoint presentations, business plans, that by itself will not be able to demonstrate that you've met some of these sufficient funds requirements. And we'll talk a little bit more about that later when we move into the investor type green card known as the EB5. But just something to be mindful of as far as that auditing and accounting is very critical for some of these visa types where finances need to be put in order. So with that, I'm going to turn this over to Shilpa Malik to begin talking about the green card strategies that we believe are suitable for an individual entrepreneur to pursue. Shilpa?
Thank you, Sang. That was very enlightening. And thank you for the quick overview of the non-immigrant visa options that are available to our listeners and to entrepreneurs. Hello, everyone. I am really thrilled to be one of your speakers. I'm Shilpa Malik, the managing attorney at VisaNation. I'm here to provide you with some viable green card options that may be suitable for entrepreneurs. So I'll be sharing some key insights and practical tips that would assist you in your immigration journey. Once again, please feel free to engage in this session. Please feel free to ask questions. We're here to help you. And of course, as Sang had previously mentioned, there's a lot of information available on our website, imi-usa.com, which addresses each of these categories in detail. That being said, I would like to now move on to the green card options that will likely be of interest to a majority, or at least some of you. While the employer-based green card, which is through the perm labor certification process, is not the focus of this webinar, I do want to touch upon it because it's one of the most common ways that people secure green cards in the United States, especially under the employment category. This typically requires a U.S. employer who has a bona fide job opportunity available to a prospective employee in a field related to their education or work experience, or a combination of both. It does go through a very stringent labor certification process, which is very closely managed and monitored by the Department of Labor. And as mentioned in one of our previous slides, this is not something that you could do as an owner of the company. You could be a really small minority owner in these situations, but if the Department of Labor believes that there's any form of influence that you exercise on the recruitment process, which is one of the requirements of this employment-based perm category, they will likely deny the application. So from perm, we'll now move on to the self-sponsor categories. The first one being the EB1C, which is available to EB1A, my apologies, EB1A, which is the extraordinary ability criteria. Now, as Sang mentioned, there is a non-immigrant category, which is the O1, which bears very close resemblance to an EB1A. However, the EB1A is the king of all green cards, as we like to call it, because it's one of the highest green cards accorded by the U.S. government to individuals. Let me just share this with you. The U.S. government loves to bring in people who add value to the economy, who add value to US's sort of prosperity, etc. So it is a great option for individuals who have achieved a level of distinction in their field. And when I talk about distinction, I'm really talking about being in the top 1 to 5% of your field. You need to have a demonstrated record of outstanding accomplishments, which could be in the form of media articles, any papers or articles you may have published in journals or magazines, which are widely read in your industry. There must be recognition and prominence in your field of expertise. You could have recommendation letters from experts in the field who are well known, who would talk about your original contributions to the field. Again, I have to reiterate the national and international importance of the work you're doing, because ultimately that's what sets you apart from the general population in terms of what you're contributing to the society, to the industry, to be basically be considered as being one of the experts in your field. You need to be consistent in your achievements. So if you did something 10 years ago, you can't really rely on that in order to get a green card now. As long as you've maintained consistency and you've grown in your field, you absolutely can use it. And your contributions have to be considered being of major significance. And when we talk about major significance, they need to be groundbreaking. They need to sort of lay the foundation of really big things in that particular industry. Now, there are people who have patents who, and they come to us all the time. Hey, I have a couple of patents. Can we go ahead and apply for an EB-1A? Unfortunately, just having a patent in your name doesn't do it. You need to show what is the commercial impact of that patent. Has it been acquired by a big entity? Is there a possibility that this patent is going to yield in millions and billions of dollars in revenue for a particular company if you were to license it to them? So, and then we also have very unique individuals who come to us for EB-1As. We've had magicians, we've had people who are CEOs who have just taken their company from point A through to point Z, and they're doing phenomenally well, and they're widely spoken about in business magazines, etc. So the more visible you are in your industry, the more recognition you have in your industry, the higher your chances are of getting an EB-1A green card. I do want to caution you, it's not one size fits all. It's a totality of circumstances. It's a totality of evidence that is considered by USCIS in an EB-1A. And these are definitely the hardest green cards to obtain an approval on. Not impossible, but definitely very hard. Again, we also have physicians who come to us saying that, hey, I'm on an expert panel, and I kind of have been invited to essentially work on research towards finding a cure for a certain disease, etc. That always is something that needs to be explored further. So when in doubt, please consult a qualified immigration expert who would be able to tell you whether you have a viable case or what else can you add to your portfolio or your profile to make it stronger. So even if you can't apply for it today, you may very well be eligible for it 2 or 3 or 4 years down the line. And again, this is the fastest way to get a green card in the United States, because there's no labor certification process involved. And for the worldwide category, the priority date, which is your place in the line to get a green card, is usually very much ahead of the rest of the world. Now we can move on to the second option, which is the EB-1C multinational executive or manager category. Now, this is quite a great option to consider for our entrepreneurs who actually own a business in their home country or outside the United States. Now, typically, when you own a business, you're expected to have grown it. You're expected to have employees in your home country or the country where your business is located. You're expected to have a good financial base with revenues and business operations in that country. And let's say you would intend to expand your business to the United States. So the first step in that direction would be to procure an L1A, which is the non-immigrant side of an EB-1C, to be able to come to the US as a multinational manager or executive to get the business up and running. When the US business has been operating for at least 1 year, and that's the minimum, and it all depends on how well your business is doing in a year's time, you can then start looking at an EB-1C as an option to get your green card. Now, an EB-1C is basically for multinational executives or managers who are permanently going to remain in the US to grow the US side of the business. Now, please remember, while your EB1C is in process, it is very, very critical that your business overseas continues to thrive and continues to have employees, because USCIS, which is the United States Citizenship and Immigration Services, will come and ask for evidence of things you did and did while you were overseas running your own company, and what is the current standing of that company while you're seeking the green card in the US, and who's actually managing the company overseas while you're in the US. Now, some of the important criteria are there has to be a qualifying relationship between the US company and the foreign company. So typically it's through common ownership, affiliation, it could be a branch office, it could be a subsidiary, etc. Then the other more important requirement is 1 year of employment in a managerial or executive capacity for at least for 1 year in the preceding 3 years prior to filing of the application. And then you need to have performed in an executive or a very senior manager role within the organization. So an executive is one who directs the policies of the organization, who makes all the relevant or critical business decisions on behalf of the organization, whereas a manager may not necessarily be performing the role of making policy decisions on behalf of the company, but could be one who actually runs a team of employees, manages a team of employees, makes hiring and firing decisions, does performance reviews, etc. And one most important thing that a lot of our clients often end up asking us is, what if I was in the United States, but I still have a company overseas? Does that qualify me because I was managing the company remotely from the US? Unfortunately, that does not qualify. You need to have worked overseas in a managerial or executive capacity. But I do want to leave you with this thought that it is a great option for individuals who don't necessarily fall under the EB1A category or the EB2 national interest waiver category, but do have this business model in place, which enables them to pursue a green card as an executive or a manager. Now we'll move on to the third option, which is the EB2 national interest waiver. Now the national interest waiver bears some similarities with the EB1A, yet it's a lot easier to get an approval for. Again, when I say a lot easier, I'm not saying that it is extremely easy. All I'm trying to say is that compared to an EB1A, a national interest waiver is likely a better option for some individuals who may meet the criteria. Now, there are two sort of elements to a national interest waiver EB2 green card. One of them being that you could be an individual with extraordinary or exceptional ability in your field, which you'll demonstrate through any research articles you may have written or any other outstanding achievements you may have had in your field of endeavor. The second option is for you to have an advanced degree, such as a master's or a higher degree in your field of endeavor, or you could have a bachelor's degree plus 5 to 10, how many years of experience past the 5-year mark in order to qualify for an EB2 national interest waiver. Now, the most critical element of a national interest waiver is to prove that your endeavor or your business is in the national interest of the US. So here I would like to sort of share a question that oftentimes our EB2 and IW potential clients ask us. I've started a business in the US. I have so many employees. I've created jobs in the US. So obviously I'm benefiting the US by creating jobs and paying taxes, etc. That unfortunately is not considered enough, because there could be many people who could set up businesses in the US, hire 10, 15, 20, 50 employees, and could claim the fact that they are benefiting the national interest. But unfortunately, that's not what the US government is looking for. They're looking to see what is your impact in a particular field, which is going to benefit the US national interest. We have people who work in the soybean industry. We have people who are dentists who have come up with, business plans which show that they intend to open up mobile clinics for providing dental services to, the low-income group of people essentially taking the service to people who cannot reach out to them. We have people who've actually created platforms for veterans to be able to easily apply for benefits which they struggle with once they leave the army. So there are many ways to create a proposed endeavor. There was a recent case that we did where this individual connected small businesses with the federal government to provide US made products for sale, wherein they acted as a conduit where the federal government was looking for products on a large scale. And then this business used to reach out to small businesses throughout the United States saying that, hey, we have this federal government contract, we would like you to fulfill it. So it was a win-win situation because he was creating opportunities for small businesses and also creating a demand for US made products. This is what the US government likes. What can you do for the country? Now, in terms of documenting exceptional ability and national interest, again, what sets you apart? Why are you the one for whom the labor certification requirement should be waived? Why should you not need a job offer to get a green card? We have to convince the government that, hey, the work that I intend to do or the work that I'm currently doing in the US puts me in a position to greatly contribute to the national interest of the US. And if you don't give me a green card, you'll be taking this opportunity away from a huge sect of the population which stands to benefit from what I do. Now we can move on to the next slide, which relates to EB5. And on this, I'll have my colleague Sang share some insights, as he had mentioned in his earlier conversation. So Sang, if you could please take over. And again, thank you all for listening to me. And I hope I was able to offer you some good options to consider while you decide which green card option would work best for you. Thank you again.
Thanks, Shilpa. You'll be right back. Just want to also say thank you so much for your questions. We are observing them in chat. We will address them in the Q&A portion. Many great questions. So just want to ask everyone's patience as we're nearing the end of our webinar presentation and we'll move into the Q&A portion. So to discuss about the EB5, again, we're going to talk a little bit about the capital requirements. So as you can see, this has been covered much in press as far as the euphemism for this is the $1 million green card, as it were. It has changed slightly in the past several years because of some reform, and policy adjustments. But essentially, the highlights of the requirements are here. And I won't get too much into the specifics, but I did want to raise a couple of interesting highlights that have come up during my time working with clients pursuing this type of visa, green card, as it were. First off, the capital requirements are very specific that they need to be out of pocket. When I say out of pocket, it means that the source of the revenue needs to be from wholly owned by you. It cannot be a loan, cannot be a gift, cannot be funding. It has to actually be gained normally through wages, investment, inheritance, revenue you've already gained from pre-existing businesses. But these will be audited, and generally speaking, it will require a very specific paper trail to demonstrate that the $1 million is unattached and wholly owned by you with no other sorts of caveats or restrictions on it. There isn't really a workaround to it. There is the million 1.05, and then there's the 800,000 if you are a target employment area. To talk a little bit about the TEA, what that means is there are sections in the United States identified by labor and commerce agencies as those who are experiencing a above average unemployment or depressed state of job opportunities. You'd be surprised if you look at the map which neighborhoods and which counties and which cities are experiencing classified as a TEA. So if one were to set up a business or operations within those neighborhoods, then it would be qualified for the lower threshold of capital requirements. I would invite those who are pursuing a new business venture and would like to look at more closely at a possibility of a TEA designation to look in the area where you live. These TEA designations are quite specific. They're not just cities or counties, they're actual neighborhoods. So you'll find that even in San Francisco, New York, Los Angeles, Miami, that TEAs will be scattered throughout their various neighborhoods. And so that could present an opportunity if you wanted to have the flexibility of living in your current metropolitan, suburban, or rural area, but you want to be specific about where you're flexible on where you actually want to set up base of operations. So with that, I think I'm going to turn it to the end of our presentation, talking about timing and planning, and I'm going to invite Shilpa back on stage. So my initial takeaway, as I talked to you about a multi-year, and this is one of the questions that I'll hopefully address, is the green card is a multi-year effort. It's not just about the preparation. It's about once filed, it takes months, if not years, for it to be processed and approved. So to understand, filing a green card does not give you immediate benefits to live and work in the United States. This is why our initial presentation talked about visa and bridge strategies, because the majority of our clients come into the US on some visa, a work visa, HOL, and then they begin parallel or concurrently beginning on their green card strategy. So it's something that you need to be mindful of, that simply filing your EB1 extraordinary ability, simply filing your multinational manager ability, simply filing the national interest ability will not suddenly give you a work card. That will take months or even years down the road. So your timeline has to be accounted for very particularly, especially if you have family and dependent members like spouses and kids who need to live and even work in the United States while they're waiting for you to get to the finish line. Shilpa?
Yeah, thank you, Sang. That's absolutely right. And I also want to point out that it also depends on your country of birth. For example, India and China are oversubscribed countries. So people who are born in those countries end up waiting much longer to pursue a green card within the United States, since there is a waiting period, and there's something called a priority date, which is assigned to each applicant under the employment-based green card category. So while EB1 is current for the worldwide category, it is not current for people who are born in India and China. And at this time, it will take about 4 to 5 years for people who are born in those countries in order to be able to procure their green cards if and when an EB1 I-140 is approved on their behalf. Whereas the worldwide category, an EB1 could be filed, EB1A, B, or C could be filed under premium processing. You could get an I-140 approval, and approximately within a year, you could have your green card, depending on whether you're inside the US on valid legal status and you'll be applying for adjustment of status. Or, well, if you're overseas, there's obviously you need to allow for the National Visa Center to process your case after the I-140 is approved, and then it goes to your U.S. Embassy to schedule you for an interview. So there are different paths for people who are in the U.S. and who decide to wait outside the U.S. while their process is underway. Now, I do see a question from Ivan Pitso, which I quickly want to address because we're still on that topic. He said that what are the benefits of an O1 if the EB1 is a much straighter way? Again, as Sang pointed out, you cannot, if you want to be in the US before you get your green card, you need to have legal status in the US. And the O1, if you do qualify for you, helps you be in the US, run your business or run your, further your endeavor while you wait for your EB1 to be processed, because green cards are not immediate. Similarly, if you move to the EB2 category, you have to remember that it's not current for any country, which means there is a wait period of about 2 to 2.5 years, sometimes even longer, for you to be able to get your green card. So having another non-immigrant status, which allows you to work and live in the United States, is often beneficial for people who actually want to be in the US while their green card process is being completed, either directly or through an employer. Other than that, sorry, Sam, please go ahead.
No, absolutely. I to just want to add one thing, Shilpa, before you close on any final thoughts. I do want to stress that premium processing comes up a lot, and we want to be clear that although premium processing is available for some case types, some visa types, for example, you can premium process your extraordinary ability, you can premium process your multinational manager, you cannot premium process your green card. The green card is a separate form type. It is filed sometimes with your EB1 green card strategy, but it's by itself. The 45 does not allow for any sort of pay for premium processing process. Green cards can take several months, if not a year or longer, depending on the specific circumstances. So this is why an expedite is not going to be available for that final leg of your green card immigration journey.
Well, that was an excellent point, Sang, because a lot of people think that the premium processing benefit carries over to the I-485 application, which is unfortunately not the case, as the I-485 requires mandatory background and security checks, which can range from a couple of months to a couple of years. So please plan accordingly. These non-immigrant visa options are for you to consider as step one towards your sort of journey in getting a green card. The green card, when it's issued to you, will give you accord you permanent resident status in the U.S. And within 5 years of getting your green card, you could also be eligible for U.S. citizenship if all the requirements for U.S. citizenship are met. With that, we would like to invite you to obviously ask any questions, and I'll pass it on to Vishal to take it further. Thank you, Vishal.
Well, thank you, Shilpa and Sang, for such an informative presentation. There are a lot of good questions here. So thank you to our audience for their active participation. So we'll go ahead and start our Q&A session. And the first question we're going to pick is from Shoaib. His question is, what if I have an LLC registered in the US and doing business, and I'm living in Dubai? Will I be eligible?
So I'll start with that. So Shoaib, and apologies for the mispronunciation. Thank you for this question. There is a bit of additional information or follow-up we would ask in the situation. Is that, what type of business? How is it operational? How many employees? Because straight off to ask, if the assumption is you are a citizen of UAE or Saudi Arabia, unfortunately, it does not have an E1 treaty trader, which means that likely, off the top of my head, H1B or L1 or entrepreneurial would be the likely strategies. H1B would require a demonstration that you would be an employee, thus a minority shareholder in the endeavor, or an L1A if you have a similar foreign offices in Dubai or somewhere else outside the US, and you will maintain both the office work site outside the US as well as the new US site, which you will be entering as an executive manager. And finally, there's the entrepreneur parole if your LLC has received sufficient capital investments. So those would be kind of my opening conversations as far as next steps. But I would invite those who are asking questions to offer any additional details they'd be willing to share on the call today as far as what type of business and whether or not there are foreign affiliates. The reason why in our questions and answers and on the Q&A chat we've asked for your nationalities is that there are specific subtypes of visas and strategies that do present opportunities depending on the nationality you're from.
Great points, Sang. The only thing I would want to add to Sohaib's question was that if he is from Pakistan, if his nationality is Pakistan, then he does have the option of pursuing an E1 or E2 based on the amount of investment he's made in the United States, and which is why knowing your nationality helps a lot, because it does open up other options that may not be available to the individual based on their country of citizenship. So just to give you a couple of examples, there are people from Australia who can apply for what's called an E3 visa, which is not available to any other country. Similarly, there are people from Canada and Mexico who can apply for a TN, which is not available to other countries. But that being said, Sohaib, L1A is a great option for you to consider as a non-immigrant option. And an E2 will also be a good option for you if you've invested substantial funds if you're from Pakistan. I hope that helps.
All right. Very detailed answer. I'm sure Shoaib will have an action plan ready and for the next steps. The next question here, actually, there are a couple of questions from Ivan. First one, I think we already covered earlier. He has another question. It's related to NIW. Ivan wants to know, is NIW required for EB1, or is it an independent path?
So to jump in, I could see the chat thread. So Vishal, thank you for pointing that out. Let me kind of hit all Vishal's points. And Shilpa, I'm happy to let you kind of jump in at any time. So as we covered in this previous slide, NIW is an EB2 case type. It's not EB1. So that's straight off. Unfortunately, there is no EB1 NIW. The EB1 in that case would be an extraordinary ability, in which case you need to demonstrate not so much the national interest, which could be connected to an insurability argument. I mean, you could say that what you're doing, whether it's AI, superstructures, charitable works, humanitarian efforts, it's the fact that it's national interest absolutely does not hurt extraordinary, but the national interest exceptionability evidence checklist is not an EB1 extraordinary ability checklist. There might be some overlap, but for the most part, they're two separate case types. Shilpa has already covered regarding how the O1 and the EB1 relate to each other, and that's simply more of a timing question of where you are in your timeline. Where do you want to live and work in the United States while you're pursuing your green card effort? Because the green card will not necessarily provide you immediate status in the U.S. You did provide some, explanation regarding your, business venture. So, if you're a startup and you've received some capital investments, I invite you to possibly look at the entrepreneurial. And I think I can kind of, before I hand it over to Shilpa, mention that if our discussion today has been fruitful and there's some great immediate follow-up questions you'd like to ask, we invite you to contact our VisaNation. We'll share that in a moment at the end of our meeting here today. And feel free to schedule a consultation with Shilpa or myself or the legal team. Vishal or Shilpa?
Yes, so there's a
Vishal,
related question from Temujin, sorry if I'm mispronouncing your name, also regarding EB2 NIW. Didn't provide a lot of details, but looks like Temujin is from Mongolia and currently in Florida, interested in EB2 NIW. Is there anything specific you'd like to add based on the nationality?
Well, the nationality has no bearing on an EB2 NIW. It's more about the endeavor that Temujin intends to undertake or has undertaken. So obviously, additional details on that would be material in determining whether a successful NIW petition package can be submitted on his behalf. That being said, I want to reiterate the fact that the U.S. government loves to see what you can do for them on a wide scale. Now, a lot of people come and tell me that, hey, I'm opening up an office in this small town in Iowa, but I'm going to do all of this with the immediate neighborhood or society or my city. While that's all great, at the same time, if the impact doesn't go past a smaller sector of the population, it will not get you to the EB2 NIW green card. You do have to show that the impact is broader and it affects a greater segment of the country. So please keep that in mind. Saying I would also like to highlight some of the pilots have approached us to secure EB2 NIWs, and they often tell us, hey, there's a great shortage of pilots in the US. Can I just get an NIW based on that? That's not how it works. Of course, there's a shortage. And then what the US government says, okay, have an airline sponsor you. If they need you, they'll sponsor you. But there are pilots who come up with great business ventures, which involve, setting up training schools or safety procedures for training younger pilots. Now, that is important to the government. You're creating a whole new generation of pilots who have the safety education, who from highly trained pilots who have had many, many flight hours, have been flying for 20, 30 years. So that's what creates the difference between somebody who knows there's a shortage, but somebody who actually can create a bigger population to address that shortage.
All right, so the next question here is from Helena. Her question is, can the EB1C be a family-owned business?
I
can take that one if you like.
Yeah,
yes,
absolutely.
Sorry, Sam, go ahead.
No, so after you're done with Jelena's question, I'd like to talk related with Gurpreet's multi-part question regarding L1s and EB1s as well.
Perfect. Sounds great. So just to answer that question, yes, absolutely. It can be a family-owned business. We, in fact, do have a lot of family-owned businesses who wish to pursue this path and have successfully pursued this path. Again, the size and operations matter. How big is your family-owned business? It could be, a 5-member team, in which case you have a weaker standing when it comes to L1A or an EB1C. However, if your business has grown to a level where you have, 20, 30, 40 employees and you have vast business operations in your home country, absolutely. open up a branch office or a subsidiary in the US, grow that for a certain time. And I do want to address one issue here that I did mention earlier. Please ensure that your US business is standing on its own legs, has a sufficient number of employees, has at least 2 or 3 years of tax returns, solid tax returns in place before you think of doing an EB1C. Because I think a lot of people think that, oh, I got my L1A, can I just apply for an EB1C next month if the company is new? The answer is no, you will be denied. So the timing of it is very critical. Sang, please take over.
Absolutely, and that answers exactly Gurpreet, who's asked similar EB1 L1 questions regarding the timing of the L1 and the EB1C. So yes, I agree with Shilpa that there needs to be some level of business activity and structure present before moving forward. Much like what I said before, the minimum checklist is not necessarily the approvable checklist. So there would be a sense of making sure that that you've grown your business enterprise for whatever category you're applying for before initially jumping right into the higher threshold of a green card approval versus a VC approval. So just again, Gurpreet, to kind of jump through your questions here. The L1 renewal, yes. So in your hypothetical, someone would be coming into the U.S. Possibly to start their new U.S. business, and in that effort, you are qualified to apply under the L1A new office category, and that's usually granted for 1 year. The sense is that USCIS would want to give you 12 months to get things going, and then once the 1 year is done, once you've established that you have sufficient business activity and the U.S. business is standing on its own, you can apply then for a 2 to 3 year renewal. And if the evidence is there, you could file an EB1C multinational manager at the same time you file your own. But it's really going to be a devil in the details moment to see whether or not you have sufficient U.S. employees. If it's just you by your office with one contractor, temporary assistant, or a head office person, I don't know whether or not we would say that would be the best time to immediately apply for a green card effort. You asked another follow-up question about buying an existing business and then applying for L1. Yeah, that's perfectly fine. The L1 is about a multinational structure, both a worksite and office outside the U.S., as well as a business inside the U.S. So the fact that you own, in this hypothesis, both the office abroad as well as the office inside the U.S. is a qualified multinational organization. So that's perfectly permissible. Let's move on to your next question.
Yes. Let's go with this question from Jitosh.
Well, I just want to conclude with Gurpreet's final questions. Thank you. Okay, so you've actually answered this question already, and yep. Okay, great. And then if you mentioned also that you're Indian-born Canadian citizen, probably want to just conclude by saying is that although India does not have E1, E2, Canada does, and as a Canadian, you also might be able to take advantage of the TN visa. Vishal, I apologize.
Or the E2. Or the E2.
Oh,
as a Canadian,
yes.
he can apply for an E2 to start his business in the United States. So that's another thing you could consider, Gurpreet, as a Canadian citizen. Now, I do want to remind you that your green cards are the priority dates for green cards are assigned based on your country of birth and not your country of nationality. So if your country of birth and your country of nationality are different, your country of birth will dictate how soon you get your green card, whereas your country of nationality just dictates what kind of visa you may qualify for. So there's a clear distinction there for people who are interested.
The next question here is from Arjun. Arjun is a startup coach, and he has a company which helps veterans in the U.S., and he wants to know if he's eligible for EB2, and if yes, then what type of investment is required?
I'll take the first go at this one. Thank you, Arjun, for sharing your question. Now, in terms of, can the question be brought up again, please, so I can take a look at it? Yeah. So you're a startup coach. You can help ex-veterans in the U.S. start their ventures with less risk. Now, again, I'm not sure what your country of nationality is, so it would be very helpful for us to have that information because the amount of time it takes for you to get your green card would depend on that. But if you do, obviously looking at what you've shared, and EB2 and IW could be a very exciting option for you, because again, if you're helping the veterans of this nation and I can create a program for them, then absolutely it would be something that the US government would love, as long as we can prove that you are uniquely positioned to do so based on what you've done in the past. And you said you've been a coach for the past 9 years, so we could use examples from your work history to establish how you're how you're specialized in this field, and what's the uniqueness you bring to this segment, which people with similar qualifications will not be able to bring. So yes, an EB2 NIW is an option you can definitely consider. And I see that you're Indian. So again, while it's a great option, it would not lead to a green card for at least 15 to 20 years, which then again may not sound super exciting, in which case we may have to move on to an EB1A. But for that, we'll need to explore your background a little bit more, to be honest with you, and see how far you can take this proposed endeavor in the near future. And we do welcome you to schedule a consultation with our office so that we can specifically look at your credentials and advise you on the best options for you.
Very detailed answer. Thanks, Shilpa. The next question, I think, is for Sang. This is about EB5, and this is from Jitosh.
Excellent. Thank you, Vishal. Thank you, Jitosh, for your patience. Sorry, we had to move around a bit before we came back to your question. So if I understand your question correctly, the question, my follow-up question to this is that how has your revenue is existing right now? Is it part of the existing business's assets? Is it a line item on your tax return? Is it basically attached to payroll or something? If it's the answer to that is it's attached and it's not fully vested in myself, then the answer is no. What the scenario that works for our clients is that all the revenue that you receive either through wages or through profit sharing or through some other qualified method, which now is fully on your own, which means you're reporting it on your personal tax returns, or it's part of your personal assets, is what would be qualified for EB5. But if those funds or assets are owned by the entity, or they are earmarked by the entity for a specific a line item or on your P&L statements or tax returns, then I would say that's probably not going to be EB5, and you're probably going to need to talk to an accountant or an auditor to determine what are qualified ways for you to transfer those funds, so that way they are fully vested in yourself as an individual with no issues on the state or federal level.
Okay, the next one is from Emily, and the question packs a lot in it. Talks about O1, EB2, EB1, so I'm not sure which one of you wants to take it. Her question is, can someone extend their O1A visa with already having EB2 NIW and priority date not current?
So the O1A, and Shilpa, I'm happy to have you add after I kind of take my first crack at this. Visually speaking, the visas and bridge strategies we're talking about, whether it's an H, an E, O, L, they're parallel track to the green card track. So essentially, they basically move it next to each other. But until you get your green card, the assumption is that for most visa types, you can continue to exercise, and you're going to need to renew your status. Now, the O1's very interesting in the sense that it's what's called a single intent visa, and it does not permit moving forward into a green card strategy. So the conservative approach would be to move your green card effort into the 485 green card stage, where you can procure an EAD work travel parole until and then move away from the O1 because there might be some scrutinization on an O1 visa or TN or some other visas available. H&Ls are the only ones which are very compatible with the green card strategy as a parallel track. But in your hypothetical, Emily, the recommendation would be is that if you do pursue O1A and EB2 NIW by itself and your priority dates are not current, you're going to want to be careful about travel. Travel is where you probably get scrutinized on your visa type, and because the I-140 national interest waiver may be on record with a customs officer, and that may raise questions. Now, there are very specific things you can explain, and there is we are understanding that O1s are not necessarily as strictly scrutinized as some other visa types, like say the F1 student visa or J1 student visa. So there is some flexibility, but this is definitely one of those situations where you want to get the timing right, and before and be mindful of using your O1A while pursuing your I-140, especially when it comes to going before an officer or renewing your O1A in the future. Shilpa?
Yeah, absolutely. Great point, Sang. I do want to add, Emily, that we've had success with people who have an approved I-140 under the EB2 NIW and getting their O1 extended, because the regulations do not prohibit anybody with an approved I-140 from securing an extension on their O1 if obviously the priority dates are not current or are several years from becoming current, as the case may be. Sang is absolutely right about traveling. I remember an immigration judge in my earlier years of career told me that, Shilpa, once a person leaves the US, that's all good. But once they try and come back to the US, a CBP officer can find any reason to create an issue with them entering the United States. So please be mindful of those requirements. I would just quickly jump to your next question about whether you can port your NIW priority date to other categories such as an EB1 and EB3. Absolutely. Once you've established a priority date, and if that application has not been revoked for fraud or misrepresentation, you absolutely can port your priority date in the future to an EB1 and EB3 as that opportunity arises.
Vishal, you're mute.
Sorry, thanks for pointing out. So we are at about 5-minute mark. So if you still have any question you're waiting to ask, now would be the time to post it in the comments below. So the next one here is from Juan Carlos. He's from Mexico and has been under E1 visa for the past a number of years. And Juan is the co-owner of the business and with offices in US and Mexico, and wondering whether he has a case for EB1C or EB2.
I'm happy to take a shot at this question. Juan, thank you for asking this question. So we do understand that you have an E1 visa, which is, again, strictly a non-immigrant visa category. That being said, if you were to apply for an EB1C or EB2 and you were to get denied, will that have an impact on your E1 renewal? It could have some sort of impact, because when you do apply, submit a DS-160, in order to renew your E1 with the U.S. Embassy overseas, or if you try and extend your I-94 in the United States, there is a question on the applications which specifically says, has an immigrant visa petition been filed on your behalf? And you would have to answer that yes in case of the denial or an approval. But at the same time, there is nothing in the regulations that prohibits you from getting an extension. Can the consular officer or USCIS exercise their discretionary authority and be like, oh, we don't believe you're a non-immigrant anymore, and because you've done this, and hence we're not going to extend your visa? It's absolutely possible. And it does happen, to be honest with you. But in these cases, what I do recommend to our clients is that please get into the green card process knowing that there's a very high chance of approval. So you do want to work with the right people. You want to have the right support, legal support, in order to file these applications. And while there's never any guarantee with the immigration authorities, the stronger your package, the higher chances of approval. So then you don't have to worry about renewing your E1 in the future.
Yeah. Vishal, I know we're 1 minute away. Before we close, we did skip one question. I'm just going to show it up here and quickly answer it. But anyone else, we thank you for your questions. We're sorry we ran out of time. We do invite you to contact our offices if you decide you like to follow up with us. But regarding, Nicole, your question, whether an O1 or the entrepreneurial is appropriate is going to depend on what level of evidence you have regarding extraordinary ability. And that's for yourself and your tech startup, or whether or not you've already accrued sufficient capital investments, maybe qualify for the entrepreneurial instead. But there's going to be a nuanced question. So, again, these are things we would welcome additional conversation on. Vishal?
Yes, so I think we just have a question, just enough time for this question from Lori. She joined late, but her question is that how to hire and start a work visa, and she is starting her S corporation.
This is a question that unfortunately cannot be answered in 1 minute, to be honest with you. Laurie, we do appreciate you asking this question, but there are many nuances that go into setting up a company, and then obviously there exists a familial relationship between you and your cousin, so that's also scrutinized both by the immigration authorities as well as the Department of Labor. You can do it, but there are quite a few requirements that need to be complied with, and we would invite you to please reach out to us independently by virtue of scheduling a consultation or submitting an inquiry, and we would be happy to address that. I did want to address one last question, and I'll just take less than 30 seconds. Ricardo Foster asked a question. He was told that he cannot port an NIW priority date to an EB3 because he didn't do a perm. Ricardo, that information is not correct. The priority date can be moved from one I-140 petition to another one, irrespective of what category it is applied under. So an EB1A priority date could be moved to an EB2 NIW or an EB2 perm or EB3 perm, and vice versa. So if somebody has an EB3 priority date, they could easily move it to an EB1A also in the future if they do get approved. So I hope that helps you.
Okay, well, questions are still coming in, but unfortunately we have run out of time at this point. So I want to take a moment to thank you all for joining. This was a very interactive experience, thanks to your participation. And as Sang mentioned earlier, uh, if you have any follow-up questions and you'd like to know more, you can visit our website, and we have different ways to get in touch with the legal team. You can book a consultation, or you can, if you just want to learn more about various types of entrepreneur startup founder visas, our website has a wealth of information. We publish latest updates, news, analysis of U.S. immigration, specifically business immigration topics quite regularly. So yes, you could check out the website, and then you can either schedule the consultation yourself, or you can give us a call. So I'll leave here for a second for you to make a note of the our contact information. Thank you, Shilpa and Sang, for being the panelists today and being so gracious with your time.
Thank you,
Thank
Vishal,
you.
for making us a part of this webinar. And I also wanted to thank all the participants. You've asked some wonderful questions, and we look forward to addressing them if you choose to reach out to us. But thank you again.
Thank you also.